Hello people, another little video for you. This one is in relation to the Mrs Briggs bicycle collision incident that happened in just north of the city of London. And that lady died because a cyclist decided to ride down the street on an Olympic style bike with no brakes at full pelt. They had a collision coming together and she died of her injuries. He ended up getting I believe he was found guilty of wanton and furious driving and not manslaughter. So that's why there was a big call in the law that it's strange that a society, or it's strange that the government has to go back to 1861, I believe, and recall some old statute in order to prosecute and get a conviction against this man. Which does seem strange, doesn't it? It's almost like why does the statute book need to look at itself and go, oh God, we haven't got anything exactly that fits the bill, and yet the law, since the beginning of time, the ability of one person to kill another person has been going on forever, whether it be on a bicycle, a horse, a donkey, a mule, a cart, whatever you want to do. And now, when it comes to 2017, 17, we have to go back to 1861 to find a statute prosecute a cyclist that hits a pedestrian, if you like. So you can kind of see there's two systems operating there. One is that the legal statute book has to have an exact definition and an exact rule, but the law, a kill is a kill. If you kill somebody, kill them. Now let's see if it was accidental or intentional, and let's see about the circumstances. This is where all the cases are the same, but all cases are different, which is Carl Lentz has talked about many times. So obviously the people who've been involved in campaigning, particularly the husband of Mrs Briggs, has been calling upon the government to, hey, we need more laws, we need not to go back to some silly statute. Everyone agrees it's silly that we have to go back to 1861 to find something to prosecute this wrongdoer with, and it's true from the government's point of view, that's what they have to do, but obviously from the law point of view, it's pretty straightforward. So we're going to have a look at this. The first thing I want to do is just look at this. This is the MP, the representative in Parliament for the man, Mr Briggs, who went to court and had, witnessed the government's complaint against the wrongdoer, the defendant. So, that element of it, the legal prosecution, the criminal prosecution has gone forward. And he was outside of court, which was in my previous video, if you look on my channel, about the cyclist. It was the last sentiment of that video where Mr Briggs addressing the press and the public outside the courthouse in relation to the death of his wife. So now it's gone on a bit, and we've come back, and this is the lady in Parliament who is
agree with me that the law
with relation to what she thinks about this. I'll just turn the volume up a bit. I think it's up as high as it goes.
On dangerous driving should be extended to include offences by cyclists. And does she also agree with me that the 1861 offence of wanton and furious driving, which the prosecution had to rely upon in this case, is hopelessly outdated?
Killing someone is killing someone, and that's not outdated, okay? But the statute book is outdated. Wanton and furious driving. And that's the charge they managed to nail on the guy. Not the manslaughter charge. The wanton and furious driving. And you hear the yeah from the Parliament. Oh, here. We need more statutes. It's almost like they have a little rummage down in their junk box just to get all excited about having the prospect of the public screaming out, begging out. Hey, we need more statutes. We need more of this stuff so that you can help us get justice.
And wholly inadequate.
Prime Minister.
Can I first of all extend our sympathies to the family and friends of the Honourable Lady's constituent who died in those tragic circumstances. And she's raised an important issue. It was, of course, I think we should welcome the fact that the prosecution were able to find legislation under which they were able to take a prosecution, but the point she makes is a general one about ensuring that our legislation keeps up to date with developments that take place, and I'm sure this is an issue that the Secretary of State...
So this is where I want to bring it back. So the Houses of Parliament is just one society in our nation. Okay. The Queen owns the nation. Okay, it's the Queen's nation, but the members of Parliament has been set up as almost like the the big society, as the term is sometimes thrown out and around there, is that because they are the big society, the dominant society, in that respect, their club rules are the biggest, the best, the most influential. So that's why they kind of come on, people, join our society, join our rule book. This is how we can manage this stuff. Hey, come on board, become a voter, become a constituent. Oh no, a constituent has died. Let's review our policy book. Okay, so this is how the game is kind of played. Now you can remember at all times the judiciary in many nations is independent, especially in England. The judiciary is independent of the government. Okay, you need to get that in your head. The laws, the people who uphold the laws, is independent of the whatever form the government is taking at that particular time. Okay, and the Queen obviously sits on the throne as the ruler of the kingdom, but she's obviously like kind of almost like contracted out, like the day-to-day administration of government, and the biggest society that's standing there getting the contract, bingo, these people here. So basically they are the biggest contract holders to the monarch in order to have this system in place, because it's at all time it's Her Majesty's government. We're doing it in your name, Your Majesty. This is for your benefit and for the benefit of your realm. Yeah, so there we are. So that's a little insight into, like, you can see, hoping you can see the distinction between when a piece of legislation doesn't sit, when it, at the end of the day, it's just someone's been killed by an accident or an intentional whatever, but someone's died. And that's as old as the hills. Someone dying is as old as the hills. And you can see that how the statute book is not quite in line with the modern day cyclist down the street hitting someone and killing them. Now we've got to slightly amend that book, bring it up to date, and they're going to do that no doubt for their society and their definition of their rules. Now they are rules, but when you're in their system and you register to vote, those rules become binding laws, and that's the difference between a law that thou shalt not kill, and a rule that wanton and furious driving. Thou shalt not wanton and furious driving. Yeah, just to highlight the difference. Okay, that's nothing more or nothing less than that. I want you to get in your head. Now here we go. So let's look at the article. Drivers who cause death by dangerous driving under the influence of alcohol or drugs now face life in jail under government plans. The maximum sentence for causing death by speeding, racing, or using mobile phones. Remember the ings, like a future tense word. Using a mobile phone has been raised to 14 years to life, making the offence equivalent to manslaughter. Hang on. So they couldn't get the manslaughter charge to stick. They got the 1861 charge to stick. And now they're saying they're going to make their own charges in line with manslaughter. A separate offence, causing death by driving whilst under the influence of drugs, is, basically they're just bringing it in line with manslaughter. The government will also create a new offence, causing injury by careless driving. Maximum sentence to be decided. The new measures are being introduced to government consultation on penalties relating to the driving-related deaths and serious injuries. It's always been a bit of a soft thing, if you're going to kill someone, sometimes it's almost worth getting in a car and running them over because, I didn't see them, I'm really sorry I had an accident. And you'll get a significantly less sentence, whether it's intentional or unintentional. Obviously, you can mess around with the system in relation to how they're going to prove either one, but it's always seen as a soft touch on causing death by driving. 90% of respondents said they believe there were sufficient. So remember, voters, representatives, constituents, respondents. These are all very Latin-based words. Sufficient needs, a new offence can cause death by careless driving, while 70% thought that the maximum penalty for offences causing death by driving should be increased to life. Especially, okay, fine. This is just who can't disagree with that? If you're killing people with being drunk at the wheel, it's pretty serious. We've taken a long, hard look at driving sentences, and we've received 9,000 submissions below an omission to our consultation. Based on the seriousness of the worst cases, the anguish of the victims being those sacrificed to the gods, families, and maximum penalties and other serious offences such as manslaughter, we intend to introduce life sentences of imprisonment for those who wreck lives by driving dangerously drunk or high on drugs. We will introduce new offence causing serious injury by careless driving, punishable by imprisonment, to fill the gap in the law, in their law, and reflect the seriousness of some of the injuries suffered by victims in this category of case. In 2016, 157 people were sentenced for causing death by dangerous driving. A further 32 convicted for causing death by careless driving whilst under the influence. We would have welcomed a broader review that considered all the offences available, prosecution procedures, and whether or not the sentences imposed were working in practice. It said, that's probably the review document, the submissions. The Prison Reform Trust also cited the government's emphasis on criminal prosecutions in its submission to the consultation. Greater use could be made by the courts of longer driving bans. So instead of sticking people in prison, they're saying here, which would still curtail liberty of people in our society to have the freedom to do something and prevent future harm for people, there we go, people now, convicted of these offences. The Prison Reform Trust said in their statement, this could be supplemented by additional targeted community-based interventions where appropriate. This includes supervision requirements and attention of anger management, drugs or alcohol support. So they're kind of being a bit more less throw them in jail. Let's actually get to the root of the problem and solve the root of the problem, which is admirable. That's essentially it. But you can see, woman dies tragically. The prosecution goes on for about 2 years. The guy gets done in the end, not for manslaughter, but for wanton and furious driving of an act. Mr Briggs calls out on everyone, says this is a tragedy. Obviously, it is a tragedy. But what he does, he diverts his concern to government, and government gets bigger. Government changes. Government seals the gap, if you like, in their legislation in order to make it easier for them to get a prosecution next time. And there we go. That's how it is. So I just wanted to wrap that up because I did a previous video on Mrs Briggs and this cycling incident that happened in London. So hopefully this will give final closure on